Thank you so much for spending the next 30 minutes with us for the webinar titled Everyone Brought AI to the Meeting, but Lawyers Were Left Holding the Pen Until Querious. Here are the topics that we are going to cover in the presentation today. Our goal is that you come away from this webinar with an appreciation about the importance of investing in your client conversations, a framework to assess the benefits and risks of adopting AI in your practice, and an understanding of why Querious can be adopted responsibly to enhance your practice like no other tool that's on the market. So let's get started. I'm Hilary Bowman, the CEO of Querious. Querious is a novel legal tech tool that enhances attorney-client conversations with generative AI. I practiced law for over 12 years as a healthcare regulatory lawyer, and I founded Querious in order to leverage technology to be a better lawyer. We're very lucky to have Lourdes Fuentes here. She's the CEO of Karta Legal. And Lourdes, thank you so much for joining us today.
Thanks for having me, Hilary. So like Hilary said, I am the CEO of Karta Legal. I am a former litigator turned legal tech and operations advisor, and I work with law firms and legal departments in their legal innovation and technology journey. I think I'm really interested in this particular tool because, as we all know, generative AI and tools that embed and incorporate LLMs into their architecture and technology are all the rage. And I'm being asked questions all the time as to, which tools to adopt and why. And I'm really interested in this particular product. After our due diligence, I think it has great potential, and I want to learn a little bit more about it and sort of advise the audience to the extent that I can in how to not only detect which technology is the right technology for you, but how to adopt it successfully.
Wonderful. Thank you. So no matter where you are in your career, without even realizing it, you've probably been making decisions about what, when, and how to adopt tech tools professionally. So take a moment to think about what's the most important tool that you're using in your legal practice. You may be thinking about legal research software, billing apps, document management systems. At Team Querious, we actually think that your most important tool is your attorney-client conversation. And Lourdes and I know from personal experience that attorney-client conversations are a critical part of legal practice, right? It's where you earn your client's trust. It's where you win their business. These conversations are really important, but they're challenging for many reasons. You have to issue spot. You have to ask great questions. You have to connect with the client, and that's just the start. Right? Laws and clients themselves are growing more complex by the day.
Yeah, and I think an important point to make is from a process improvement, Lean Six Sigma perspective, attorney-client meetings are both high frequency and high impact. But a lot of law firms and or legal departments are not applying discipline to that very important process. And it's a classic example of waste, right? Repetition, rework, missed insights. Like you have to check with your team. Did the client say this? Why did they say that? Why didn't I respond in this particular way? So all of that inefficiency costs time and trust. And if it's something that can be fixed with technology, we certainly want to look into it.
Yeah, great point. So these conversations, they're not just consequential. These conversations make up almost half of how we attorneys spend our time. So we've talked to law firms of all shapes and sizes. They've shared that on average, their attorneys are spending almost 5 hours a day in virtual client meetings. So that means a 10-attorney firm is spending 12,500 hours per year in virtual meetings. A 100-attorney firm is spending 125,000 hours in virtual meetings every year. So despite the importance and the time-intensive nature of these conversations, attorneys largely have not had access to technology that really helps them make the most of these conversations. In other words, there's been a real technology gap. And so at Querious, we thought there has to be a better way. And so we've reimagined attorney-client conversations. So here's how. So Querious at its core is an AI assistant that specifically is tailored to the practice of law, and it helps you maximize advice, minimize admin work after the meeting. So Querious integrates into your calendar and it joins your virtual meeting, whether it's in Teams, Zoom, or Google Meet. This tile here with our branding is transparent to everyone in the meeting. This sidebar that you see on the right is only visible to the attorney, and that's by design. So during your meeting, Querious flags potential legal issues for you to consider in real time. So here an attorney and client are discussing starting a fishing business in New England. So Querious flags issues about importing a boat or employing an unpaid intern. By spotting these issues, attorneys can develop a better legal strategy and identify business opportunities. During the meeting, Querious also provides the attorney with access to relevant legal content. So here in this scenario, Querious ensured that I had access to information about the fees, the paperwork, what to expect when importing a boat. By providing this content, the attorneys have information at their fingertips. So a senior attorney can cross-sell better. A junior attorney can just learn to become independent faster. They have that on-the-spot training. During the meeting, Querious also suggests insightful questions. So in keeping with this scenario, the attorney's prompted to clarify, how long have you been talking to someone about purchasing the boat? How far along are you in the process? As well as what are the roles and responsibilities of your intern? By covering these critical details, attorneys can avoid those unnecessary follow-ups. After the meeting, Querious also automatically drafts your summary email. So imagine this is something you can easily send to a client, confirming that you're on the same page. It's also an email that can be sent to your colleagues to kick off collaboration. Lastly, after the meeting, Querious drafts this detailed set of notes. So these detailed notes give you just the information that you need without having to manually take notes. And so you can really focus on the conversation when it's happening. You can also edit these as well after the conversation, and they're available for 7 days in your dashboard. You can also easily export them to a document management system. And here's the best part. Private practice attorneys really enjoy that there's this billing entry at the top of the notes document that is pre-drafted. It already provides your narrative as well as the timestamp that you can easily incorporate into your bills. So here's another plus. Querious just follows you into your next meeting. So regardless of the platform, it will follow you throughout the day and support you in the way that you normally practice. And this is just a glimpse of what the dashboard looks like. All right. So you and your organization may have concerns when you think about adopting new technologies such as Querious. That is a totally normal feeling. Attorneys have encountered what we're calling the tech dilemma several times before in history. And Lourdes, I think you can provide some insight on this topic, especially in light of the consulting work that you've done over the years.
Yeah, not only the consulting work, but all of the litigation work that I did prior to the consulting work.
Yes. Yes.
It is fascinating to me that a tool like this can actually add so much to your efficiency. But the question, of course, that we have is like, what are the guardrails that prevent this from becoming just another tool that creates more work and adds legal risks, right? There are a lot of AI recording tools, so this is starting to feel like an e-discovery nightmare. So we're at the point that we were in e-discovery, well over a decade ago, with risks that need to be addressed really early on, so that they don't become an issue later. So I think what I would like to walk away with is for our audience is that it's not should we adopt AI, is how can we afford not to, but how are we doing it ethically and safely? That's really the question that all lawyers will have of this and other tools.
Yeah, definitely. I think you've touched on a perfect point. So before we hop into the real specifics with that, I will just highlight. So we've encountered these questions before. So here's a fun fact. When the fax machine came out in 1966, we attorneys were questioning, Can we accept signatures in a, that are transmitted via fax? Are those legit? Are they admissible? Or can we use the fax machine in a crowded office? And, will it disclose sensitive client information? So all the questions that you're raising about AI, we've raised similar questions and had to struggle with similar objections in the past. So we know how to work through this. We're attorneys. And so in order to facilitate this process, Querious actually came up with a framework of how to look at new legal tech tools. So here's an example of the framework, and I'll just walk through it as it applies to Querious. So at the first level of due diligence, that's the first row of the table, we recommend looking at the vendor's experience, the expertise, the product architecture, and the terms and conditions. So if we were doing this exercise with Querious, we would identify that Querious is a vendor, a legal tech vendor that was founded by practicing attorneys, and we are advised by legal industry experts. Our product architecture is very carefully built in a secure cloud environment. It's using privately deployed large language models. Of course, those are the engines that behind the scenes are producing those issue and question prompts that you saw on the sidebar. And in terms of the terms and conditions, our service agreement, we are very transparent that we are not using client data to train our models. So while we have privately deployed models, we're not using customer data to further improve or refine those models. We're using it as context. And so we have very limited data retention. And the last thing I'll highlight is that we do offer a free trial. I'll talk more about that later in the webinar. So if you were doing due diligence on Querious and you are satisfied with the first layer of diligence you've done, which we just sort of talked through, the next layer would be to look at the ethical, privacy, and security considerations and our reputation in the market. So let's touch briefly on ethics. One of the key features of our tool is that sidebar. So you saw it earlier in the demo. That is where the attorney sees the prompts. The client does not see those prompts, and that's by design. We want the attorney to stay in control, to really have control of the professional judgment of legal practice.
I think
Yeah,
it's very important
yeah.
that you are being really upfront with your evaluation matrix,
Mm-hmm.
because I think a lot of lawyers maybe haven't thought about that ethical framework and that operational risk.
Mm-hmm.
So I think this is very helpful
Mm-hmm.
to consider, and I think you have anticipated the big ethical red flags that one would. And I just want to note something really important here. I
Mm-hmm.
like the fact that in your demo, when you showed it, the Querious logo is visible to everyone,
Yes.
which really is very important because I see so many AI recording tools where that is not presented up front and it's kind of hidden.
Mm-hmm.
And a lot of times you're being recorded without even consent, which is a violation of privacy laws in I
Yes.
don't know how many states.
Yeah.
So I like the fact that this is done, that you've architected your product this way. Very
Thank
nice.
you. Yeah, thank you for highlighting that. Yeah, in terms, that was a great segue into the product architecture and the privacy and security here. So we, from the very beginning, knew this would be a tool used by attorneys. So when we process conversation, the first step we take is to pull out personal information. So that never reaches the large language models. We also have implemented SOC 2 controls. So this is just a security framework that is industry standard at this point. And we've also passed audits by Microsoft, Zoom, and Google in order to be a multi-platform solution. So we've jumped through a lot of hoops just within the past year. And then lastly, I'll just touch on reputation. So we have been approached by state bar associations, especially after being at the ABA Tech Show. We've also been approached by practice management tools to do integrations with them as well. And so really appreciate their support, and they recognize the value in our tool. All right. So the next thing we'll just dive into in a little bit more detail. So you may be thinking, well, this sounds like a very useful tool, but what about privilege? That is one of the most important questions that we receive from individuals who are reviewing our product. So let's just hit it head on. The most really at a high level, privilege is the protection of attorney-client conversations, communications as part of representation. So this idea of whether technology is a third party that waives privilege is a question that we've had to ask when we adopted email as a way of communicating with our clients. We've also considered it in the cloud storage conversation and adopting virtual meetings. So what I've learned from those legal ethics opinions and what I've confirmed with experts is that technology is not a third party that waives privilege in those instances when two things happen. One, the parties had an expectation of privacy when they were using those tools, and reasonable privacy and security measures have been put in place. And so what I've highlighted here on the slides are all the steps, at least most of the steps of what we've done in order to ensure that our product is private and secure.
I have a quick question or note.
Yes.
I'm sure a lot of people have now heard about
Mhm.
the recent Southern District Court ruling that required OpenAI to save their logs.
Yes.
How does this sort of differ from where you guys are with your tool?
Yes, that's a great question. So I think that headline that has been going around, I've seen it on LinkedIn, in the news. It really underscores the importance of why product architecture matters in legal tech. Here's why. So if you are an attorney, you have an individual account with ChatGPT, you are using OpenAI's public API, right? You are using an engine that lots of different users are using, and you're putting your client data into that. Even if you opt out of OpenAI using your data to train their model, that data you are given OpenAI can still be subject to legal demands, like this recent court order, which applies to the public version of ChatGPT, of OpenAI. So even the prompts that you've put into ChatGPT will be retained as part of this court order. And so, it remains to be seen. We will find out how this story plays out. So you have now put client data at risk of being retained and potentially disclosed. And that just to me emphasizes why tools need to be purpose built for the legal industry. So from the very beginning at Querious, we built our product in a way we knew this is going to be used in attorney-client conversations, and we use privately deployed large language models. So I mentioned that earlier. This means like picture a fence, that's our cloud environment. We have two large language models inside of our cloud environment that only we use. So the traffic in and out of those large language models is only from conversations that we are a part of, that Querious is a part of. And so that court order does not impact what we do because we have privately deployed our models. We are not using the public model. So I'll say it one more time, but product architecture matters, especially in legal tech.
Indeed, I 100% agree.
All right. So I think you mentioned this earlier.
Yeah, I
Yep.
really would like to get the specifics as to how your tool differs from other AI note takers.
Yes, no, that is a great question, and we do get this a lot when we're doing the demo. Attorneys have said, "Oh, I use Fathom or Otter or Firefly." So the major differentiator with Querious is that we produce real-time legal insight. So during the meeting, we are feeding the attorney prompts about potential legal issues, questions, and relevant legal content. Note takers are not providing that value. We also differentiate ourselves because we've gone above and beyond with privacy and security standards that are consistent with what lawyers demand. To put it bluntly, I don't think that general purpose AI note takers have product managers that are sitting around reading legal ethics opinions on privilege. It's just a guess, but I don't think that's the case. So that's how we're different from note takers.
How about in the training or how long you keep the data and, the transcription of, word to word, what's
That
happened during the call? How is that different?
Yes, no, that's a good thing to highlight. So, note takers, they create an audio and transcription file of the entire conversation, and that persists forever. It's out there in many cases. You can't control what happens to that if it gets copied to other databases. What we've done is honestly the opposite. So we have processed your conversation in snippets throughout the meeting. And then at the end of the conversation, once we generate your summary email, your detailed set of notes, we delete those files. So there is no record of an entire audio file of your conversation, of an entire transcription. It's never created in the first place, and we don't retain it after the conversation. So what remains from your meeting is your summary email and your detailed notes, and we only keep that for 60 days, and then even that is discarded.
I think that is so important to highlight
Mhm.
because in conversations and in industry articles that I'm writing, one of the main concerns that I have with AI recording tools
Mhm.
is the explosion of that transcribed data that exists. And people are not even aware
Mhm.
that with, any litigation, a litigation hold can impact the retention of all of that. And to the extent, another layer of complexity, to the extent that some of that transcription then becomes summarized through Gen AI,
Mhm.
generation,
Yeah.
then you have data that may have been misinterpreted by the AI that is being
Mhm.
kept in your system and potentially subject for discovery later on. So that I think is a huge differentiator and a very good selling point for your tool versus others.
Thank you. Yes. I think that's also a great point to emphasize too is whatever summaries we do create, they are editable by the attorney so that the attorney controls what the summary email looks like, what the notes look like, and those are not saved or distributed to anyone unless the attorney decides that they in fact want that to happen. So that just sort of supports our whole objective here is to keep the attorney in control of professional judgment. All right. So, quick note here, I want to be careful and leave just a few minutes for questions, but be on the lookout when you are evaluating legal tech tools. Some of them, when implemented, can reduce the high value legal work that you're doing. And so, a unique part about Querious is that, even at an average billing rate, say 353 an hour, under an annual subscription, if you're using our tool just and you find 16 minutes of billable work, the tool will pay for itself. And the reason we can say that is we are a tool that normally saves you from an efficiency standpoint and reduces non-billable admin work. We're also helping you find new billable work. And that's a really unique feature is the tool that's helping you look for legal issues in your conversation and growing your practice in rather than just focusing on efficiency.
Right. And I think of ROI not only as the dollars, right? But there are other um, factors to consider, right? The burnout, staff retention,
Mhm.
whether your attorneys are spending a lot of time doing the type of work that is not truly intellectual, whether
Mhm.
it's figuring out the time that they spent in a conversation to make sure that, it's properly recorded, whether it's, doing the summaries of these calls for other people that miss the call. Things like that are not that satisfying,
Mhm.
yet they need to be done. So to the extent that a tool reduces the time spent in that sort of low value work in terms
Mhm.
of, the intellectual stimulus that someone gets out of it, I think that's really important to highlight. One thing for the people that are interested in this tool
Mhm.
to consider really from where I stand, which is the change management and the process improvement part of the process, is to emphasize that you need not just the product and not just a great technology in place, but your rollout strategy, training, support, piloting in the right way with, a few case studies, with people that can then become champions of the tool moving forward to the rest of the organization. So vet the tool, obviously, and how your lawyers are going to use it and train and monitor and make sure that you create a process for the exception handling and that I think that is the key to a successful implementation of Querious and anything else.
Yeah, no, I'm so glad you mentioned that. We've had support from, other folks in the legal tech industry that this is really practical. I think you can see the quote here. It's a unique product. It's practical. It's easy to adopt. But to your point, while we can make this available, the long-term use and adoption really is going to depend on how much you invest up front, in terms of having folks that use it from the beginning. One of the things we absolutely love with our users is that, when we find folks that have feedback about the product, when they tell that either to our sales folks or they send us an email, that becomes part of our product roadmap. That is what shapes where this tool becomes. And I love that as an attorney myself, that there is, now a tool, an option out there to improve your attorney-client conversations that you can influence, that you can be a part of if you really take an interest in it. So with that, I'll just quickly wrap up here, and then we'll have a few minutes for questions from the audience. So if you're out there, please submit your questions right now. But just to wrap up, so for decades, attorneys have relied solely on our intellect, right? Our ability to multitask, being detail oriented. But I think it's all clear to us that the demands of the practice of law, the client expectations have just required something more. We've had to innovate. We've had to tailor our tech to the unique challenges that attorneys face every day. And so Querious represents not just the future of attorney-client conversations, but this evolution in legal practice. So imagine a future where you are going into your virtual client conversations and you're not just spending time there, you're investing. You're investing in deeper insights and more thorough advice. Imagine where, Lourdes, you touched on this earlier, where these administrative burdens, the drudgery of legal practice, it no longer detracts from your profound satisfaction to be a counselor to your client. That was the reason why we all went into law, and sometimes that gets a little bit lost. So I hope today that we've shown Querious is a vision for this reality of how you can have real-time actionable insights in your meetings. You can seamlessly handle administrative tasks, and that just frees you up in order to be able to focus on your client relationships. So we're inviting you to not just adopt Querious, but really to embrace this new standard for legal practice of how we can be more efficient, deliver excellent advice, and still practice ethically and responsibly. So together, let's transform the conversations that we have today into the opportunities that we seize tomorrow. Thank you.
Thank you.
All right. So I have one question that came in. This was about, okay, so it says, how does Querious ensure it supports, not replaces attorney judgment? And there's a few different places where I called this out. Okay, so I think from the product itself, earlier in the demo, so the way that we ensure the attorney stays in control, one is through the sidebar. So that sidebar is only visible to the attorney. The client doesn't see that information unless the attorney mentions it. And we also send those post-meeting summaries only to the attorney's inbox, and the attorney only has access to the notes through their own dashboard. So that information is not distributed to anyone, to clients, to colleagues, unless the attorney decides that it's a good idea.
And I think to the extent that the notes give the attorney ideas that he or she may not be ready to discuss right away, at least the summary of that makes it a really easy sort of follow-up email and then addressing that later. So it just puts a placeholder on really important issues that can even create more work within a law firm, right? It can be cross-departmental work that comes out of these discussions, and that can be handled subsequently from the actual call. But I do think that using this tool the right way could really change the way that we practice our client calls and our internal training calls, et cetera.
Yeah. Yeah, well, thank you. Thank you so much, Lourdes, for joining us.
Oh,
We are
sure.
at time, but if anyone has other questions, please feel free. Here's our contact information. I'll just make sure this is available too. Please reach out to us. As you can tell, we're both very passionate about this topic and love to talk to folks about it. So thank you all for your time.
Thank you.